a WikiVidi documentaries production. Don't forget to like and subscribe. Enjoy. John Roberts. John Glover Roberts Jr. is an American lawyer serving as the 17th and current Chief Justice of the United States since 2005. He was nominated by President George W. Bush after the death of Chief Justice William Rehnquist, and has been described as having a conservative judicial philosophy in his jurisprudence. Even so, Roberts has shown a willingness to work with the Supreme Court's liberal bloc, and is regarded as a key swing vote on the court. Roberts was born in Buffalo, New York, but grew up in Northwest Indiana and was educated in a private school. He then attended Harvard College and Harvard Law School, where he was a managing editor of the Harvard Law Review. After being admitted to the bar, he served as a law clerk for Judge Henry Friendly and then Rehnquist before taking a position in the Attorney General's office during the Reagan Administration. He went on to serve the Reagan Administration and the George H.W. Bush administration in the Department of Justice and the Office of the White House Counsel, before spending 14 years in private law practice. During this time, he argued 39 cases before the Supreme Court. Notably, he represented 19 states in United States v. Microsoft Corporation in 2003. Roberts was appointed as a judge of the United States Court of Appeals for the District of Columbia Circuit by George W. Bush. During his 2-year tenure on the D.C. Circuit, Roberts authored 49 opinions, eliciting 2 dissents from other judges, and authoring 3 dissents of his own. In 2005, Roberts was nominated to be an Associate Justice of the Supreme Court, initially to succeed retiring Sandra Day O'Connor. When Rehnquist died before Roberts' confirmation hearings began, Bush instead nominated Roberts to fill the Chief Justice position. Roberts has authored the majority opinion in many landmark cases, including Parents Involved in Community Schools v. Seattle School District No. 1, Shelby County v. Holder, and National Federation of Independent Business v. Sebelius. Early life and education. John Glover Roberts was born in Buffalo, New York, the son of Rosemary and John Glover, Jack Roberts Sr. His father was a plant manager with Bethlehem Steel. He is Irish, Welsh, and Czech ancestry. When Roberts was in 4th grade, his family moved to Long Beach, Indiana. He grew up with 3 sisters, Kathy, Peggy, and Berber. Roberts attended Notre Dame Elementary School, a Roman Catholic grade school in Long Beach. In 1973, he graduated from La Lumiere School, a Roman Catholic boarding school in LaPorte, Indiana, where he was a student and athlete. He studied 5 years of Latin, some French, and was known generally for his devotion to his studies. He was captain of the football team, and was a regional champion in wrestling. He participated in choir and drama, co-edited the school newspaper, and served on the athletic council and the executive committee of the student council. After graduating from high school in 1973, Roberts entered Harvard University as a history major. Due to his academic excellence in high school, Roberts entered Harvard with sophomore standing. One of his first papers, Marxism and Bolshevism, Theory and Practice, won the William Scott Ferguson Prize for Most Outstanding Essay Assignment by a sophomore history major. He graduated in 1976 with a B.A. summa cum laude, having written a senior honours thesis entitled, Old and New Liberalism, the British Liberal Party's Approach to the Social Problem, 19,061,914. Roberts originally planned to pursue a PhD in history and become a professor, but decided to study law instead. He attended Harvard Law School, where he was a managing editor of the Harvard Law Review. He graduated in 1979 with a J.D. magna cum laude. Early legal career. After graduating from law school, Roberts clerked for Judge Henry Friendly of the U.S. Court of Appeals for the Second Circuit from 1979 to 1980. From 1980 to 1981, he clerked for Justice William Rehnquist of the U.S. Supreme Court. From 1981 to 1982, he served in the Reagan Administration as a special assistant to U.S. Attorney General William French Smith. From 1982 to 1986, Roberts served as associate counsel to the president under White House counsel Fred Fielding. Roberts then entered private law practice in Washington, D.C., as an associate at the law firm Hogan and Hartson. As part of Hogan and Hartson's pro bono work, he worked behind the scenes for gay rights advocates, reviewing filings and preparing arguments for the Supreme Court case Roma v. Evans, which was described in 2005 as the movement's most important legal victory. Roberts also argued on behalf of the homeless, a case which became one of Roberts' few appellate losses. Another pro bono matter was a death penalty case in which he represented John Ferguson, who was convicted of killing 8 people in Florida. Roberts left Hogan and Hartson to serve in the George H.W. Bush administration as Principal Deputy Solicitor General from 1989 to 1993 and as Acting Solicitor General for the purposes of at least one case when Ken Starr had a conflict. In 1992, George H.W. Bush nominated Roberts to the United States Court of Appeals for the District of Columbia Circuit, but no Senate vote was held, and Roberts' nomination expired at the end of the 102nd Congress. Roberts returned to Hogan and Hartson as a partner and became the head of the firm's appellate practice in addition to serving as an adjunct faculty member at the Georgetown University Law Center. During this time, Roberts argued 39 cases before the Supreme Court, prevailing in 25 of them. He represented 19 states in United States v. Microsoft. Those cases include, during the late 1990s, while working for Hogan and Hartson, Roberts served as a member of the steering committee of the Washington, D.C. chapter of the Conservative Federalist Society. In 2000, Roberts traveled to Tallahassee, Florida to advise Jeb Bush, then the governor of Florida, concerning the latter's actions in the Florida election recount during the presidential election. On the D.C. Circuit, on May 10, 2001, President George W. Bush nominated Roberts for a different seat on the D.C. Circuit, which had been vacated by James L. Buckley. The Senate at the time, however, was controlled by the Democrats, who were in conflict with Bush over his judicial nominees. Senate Judiciary Committee Chairman Patrick Leahy, DVT, refused to give Roberts a hearing in the 107th Congress. The GOP regained control of the Senate on January 7, 2003, and Bush resubmitted Roberts' nomination that day. Roberts was confirmed on May 8, 2003, and received his commission on June 2, 2003. During his 2-year tenure on the D.C. Circuit, Roberts authored 49 opinions, eliciting 2 dissents from other judges, and authoring 3 dissents of his own. Notable decisions on the D.C. Circuit include the following: Fourth and Fifth Amendments, Hedgepeth v. Washington Metropolitan Area Transit Authority, 386 F.3d 1148, involved a 12-year-old girl who was arrested, searched, handcuffed, driven to police headquarters, booked, and fingerprinted after she violated a publicly advertised zero-tolerance, no-eating policy in a Washington metro station by eating a single French fry. She was released to her mother 3 hours later. She sued, alleging that an adult would have only received a citation for the same offense, while children must be detained until parents are notified. The D.C. Circuit unanimously affirmed the district court's dismissal of the girl's lawsuit, which was predicated on alleged violations of the Fourth Amendment and Fifth Amendment. No one is very happy about the events that led to this litigation, Roberts wrote, and noted that the policies under which the girl was apprehended had since been changed. Because age discrimination is evaluated using a rational basis test, however, only weak state interests were required to justify the policy, and the panel concluded they were present. Because parents and guardians play an essential role in that rehabilitative process, it is reasonable for the district to seek to ensure their participation, and the method chosen, detention until the parent is notified and retrieves the child, certainly does that, in a way issuing a citation might not. The court concluded that the policy and detention were constitutional, noting that The question before us is not whether these policies were a bad idea, but whether they violated the Fourth and Fifth Amendments to the Constitution, language reminiscent of Justice Potter Stewart's dissent in Griswold v. Connecticut. We are not asked in this case to say whether we think this law is unwise, or even asinine, Stewart had written. We are asked to hold that it violates the United States Constitution, and that I cannot do. Military tribunals. In Hamdan v. Rumsfeld, Roberts was part of a unanimous circuit panel overturning the district court ruling and upholding military tribunals set up by the Bush administration for trying terrorism suspects known as enemy combatants. Circuit Judge A. Raymond Randolph, writing for the court, ruled that Salim Ahmed Hamdan, a driver for al-Qaeda leader Osama bin Laden, could be tried by a military court because the court held open the possibility of judicial review of the results of the military commission after the current proceedings ended. This decision was overturned on June 29, 2006 by the Supreme Court in a 5-3 decision, with Roberts not participating due to his prior participation in the case as a circuit judge. Environmental regulation. Roberts wrote a dissent in Rancho Viejo, LLC v. Norton, 323 F.3d 1062, a case involving the protection of a rare California toad under the Endangered Species Act, when the court denied a rehearing en banc. 334 F.3d 1158. Roberts dissented, arguing that the panel opinion was inconsistent with United States v. Lopez and United States v. Morrison in that it incorrectly focused on whether the regulation substantially affects interstate commerce rather than on whether the regulated activity does. In Roberts' view, the Commerce Clause of the Constitution did not permit the government to regulate activity affecting what he called a hapless toad that, for reasons of its own, lives its entire life in California. He said that reviewing the panel decision would allow the court alternative grounds for sustaining application of the act that may be more consistent with Supreme Court precedent. Nomination and confirmation to the Supreme Court. On July 19, 2005, President Bush nominated Roberts to the U.S. Supreme Court to fill a vacancy that would be created by the retirement of Justice Sandra Day O'Connor. Roberts was the first Supreme Court nominee since Stephen Breyer in 1994. Bush announced Roberts' nomination in a live, nationwide television broadcast from the East Room of the White House at 9 p.m. Eastern Time. Chief Justice William H. Rehnquist died on September 3, 2005, while Roberts' confirmation was still pending before the Senate. Shortly thereafter, on September 5, Bush withdrew Roberts' nomination as O'Connor's successor and announced Roberts' new nomination to the position of Chief Justice. Bush asked the Senate to expedite Roberts' confirmation hearings to fill the vacancy by the beginning of the Supreme Court's session in early October. Roberts' testimony on his jurisprudence. During his confirmation hearings, Roberts said that he did not have a comprehensive jurisprudential philosophy, and he did not think beginning with an all-encompassing approach to constitutional interpretation is the best way to faithfully construe the document. Roberts analogized judges to baseball umpires. "It's my job to call balls and strikes, and not to pitch or bat." Roberts demonstrated an encyclopedic knowledge of Supreme Court precedent, which he discussed without notes. Among the issues he discussed were stare decisis. On the subject of stare decisis, referring to Brown v. Board, the decision overturning school segregation, Roberts said that the court in that case, of course, overruled a prior decision. "I don't think that constitutes judicial activism, because obviously if the decision is wrong, it should be overruled. That's not activism. That's applying the law correctly." Roe v. Wade. While working as a lawyer for the Reagan Administration, Roberts wrote legal memos defending administration policies on abortion. At his nomination hearing, Roberts testified that the legal memos represented the views of the administration he was representing at the time and not necessarily his own. "Senator, I was a staff lawyer. I didn't have a position," Roberts said. As a lawyer in the George H.W. Bush administration, Roberts signed a legal brief urging the court to overturn Roe v. Wade. In private meetings with senators before his confirmation, Roberts testified that Roe was settled law, but added that it was subject to the legal principle of stare decisis, meaning that while the court must give some weight to the precedent, it was not legally bound to uphold it. In his Senate testimony, Roberts said that, while sitting on the appellate court, he had an obligation to respect precedents established by the Supreme Court, including the right to an abortion. He stated, "Roe v. Wade is the settled law of the land. There is nothing in my personal views that would prevent me from fully and faithfully applying that precedent, as well as Casey." Following the traditional reluctance of nominees to indicate which way they might vote on an issue likely to come before the Supreme Court, he did not explicitly say whether he would vote to overturn either. Confirmation. On September 22, the Senate Judiciary Committee approved Roberts' nomination by a vote of 13-5, with Senators Ted Kennedy, Richard Durbin, Charles Schumer, Joe Biden and Dianne Feinstein casting the dissenting votes. Roberts was confirmed by the full Senate on September 29 by a margin of 78-22. All Republicans and the one independent voted for Roberts. The Democrats split evenly, 22-22. Roberts was confirmed by what was, historically, a narrow margin for a Supreme Court justice. However, all subsequent confirmation votes have been even narrower. On the U.S. Supreme Court, Roberts took the constitutional oath of office, administered by Associate Justice John Paul Stevens at the White House, on September 29. On October 3, he took the judicial oath provided for by the Judiciary Act of 1789 at the United States Supreme Court building, prior to the first oral arguments of the 2005 term. Justice Antonin Scalia said that Roberts pretty much runs the show the same way as Rehnquist, albeit letting people go on a little longer at conference. But he'll get over that. Roberts has been portrayed as a consistent advocate for conservative principles by analysts such as Jeffrey Toobin. Garrett Epps has described Roberts' prose as crystalline, vivid, and often humorous. Seventh Circuit Judge Dianne Sykes, surveying Roberts' first term on the court, concluded that his jurisprudence appears to be strongly rooted in the discipline of traditional legal method, evincing a fidelity to text, structure, history, and the constitutional hierarchy. He exhibits the restraint that flows from the careful application of established decisional rules and the practice of reasoning from the case law. He appears to place great stock in the process-oriented tools and doctrinal rules that guard against the aggregation of judicial power and keep judicial discretion in check: jurisdictional limits, structural federalism, textualism, and the procedural rules that govern the scope of judicial review. The Chief Justice was ranked 50th in the 2016 Forbes ranking of the world's most powerful people. Early decisions. On January 17, 2006, Roberts dissented along with Antonin Scalia and Clarence Thomas in Gonzales v. Oregon, which held that the Controlled Substances Act does not allow the United States Attorney General to prohibit physicians from prescribing drugs for the assisted suicide of the terminally ill as permitted by an Oregon law. The point of contention in the case was largely one of statutory interpretation, not federalism. On March 6, 2006, Roberts wrote the unanimous decision in Rumsfeld v. Forum for Academic and Institutional Rights that colleges accepting federal money must allow military recruiters on campus, despite university objections to the Clinton administration-initiated "Don't Ask, Don't Tell" policy. Brought to you by WikiVidi Documentaries. Would you like to know more?